May it please the Lordship. Lordship, I have already circulated the adjournment slip. I'd like to mention, Obliged.
May it please your Lordship. Your Lordship, just a prayer with regard to item number 3, your Lordship. The name of the additional AG be reflected.
Additional Advocate General, Mr.
Mizoram, your Lordship. Mr. A. Collier. Deeply obliged.
May I please, Lordship?
Yes.
May I please? I beg to mention item 12, Lordship. In this case, Lordship, today we are going to file one affidavit in reply filed by the government. So, adjourn for it.
State government must submit the filing in additional during the course of the day. The same with that with the record, but it is notified 3 weeks.
Obliged, Lordship.
May I please, Lordship? Well, we have filed a writ appeal on 3/4/2023, Lordship. We have some urgency, Lordship. Can it be listed on the 10th of?
What is the date of the judgment?
My date of judgment is 14/3/2023.
Okay, 10.
Obliged.
May I please, your Lordship?
Yes.
Lordship, I beg to mention item 11 of the daily list.
11th is already adjourned.
Deeply obliged.
Yes. Yes.
Number 1 of daily list for motion.
Yes.
My lord, here, my lord, they have filed the affidavit. Day before yesterday, I have received. Where they have, my lord, categorically stated the property is the same, my lord, wherever the property plays with the bank. So, my lord, my prayer is this, my lord, this is a specific, my lord, I pleadings is this. The property is not the same, which is, my lord, plays with
That
the bank.
becomes a disputed
So
question
one
of fact.
report may be called from this officer, that will be clear from.
Sir, then that becomes a disputed question of fact.
Yes, my lord.
Why is the writ court supposed to go into it?
No, that's not civic, only for report, my lord.
But why? You go before the DRT and demonstrate.
My lord, so far in my fundamental right is concerned, my lord, that they have prevented me from selling and my lord, other leasing and. So this is involved there. That is where my report.
Question here is, sir, that you say that the property is not the one which was secured assets.
Yes,
It's different from that. They said that it is the same property.
yes, my lord.
Then it becomes a disputed question of fact.
That is-
We are not taking evidence in that petition, sir.
I am not on.
We will leave you at liberty. Approach DRT. That's the only way out, sir.
Even then, my lord, so far my lord, right of the selling and the leasing is concerned. But this is fundamental right. So that should be my lord, cannot DRT interpret.
Selling and leasing secured assets is not a fundamental right.
Yes, my lord.
They
it's
have the
secure.
first lien on that.
But these properties no longer exist, my lord. This is already gone. It is under the erosion, it is false. So they are now.
Maybe that they will take care of the things.
Yes, my lord.
Okay, so we relegate you to approach the DRT.
Master.
Affidavit has been received. Can we get their affidavit, please? When did you file it?
It is on 3/4 I have received, my lord. Probably they have filed on 3rd. On 3rd.
Give us a copy. Give us a
Yes, the
copy.
copy is there, my lord.
Yes. No, we'll take it from him. Don't worry.
There is a marking, my lord. I am sorry, my lord, for my convenience.
Don't bother about these things. These technicalities, they just don't
Even then,
hold
my
us
lord,
back. Don't
this
worry.
is my duty, my lord. In page number 28, they have mentioned, my lord.
Yes.
29, my lord.
Yes. Newly searched property. Different land, yes. So that then it becomes a disputed question of fact. You have not given any documentary evidence to support this. Dismiss petitioner relegated to approach the DRT for ventilating grievances. You want us to extend limitation?
Yes, my lord.
We'll permit you 14 days time to file the application.
My lord, instead of dismiss, that may be disposed of, my lord.
Disposed of. All right. Graceful dismissal. Okay.
Even the word is a different, my lord. That will be
Yes.
very good.
Okay. Understood. Yeah.
Item number 2.
Last of my lord.
May I please, my lord? My lord, the order passed by the Central Administrative Tribunal on the challenge,
Yes.
whereby the order of recovery passed by the department was set aside. My lord, in this
Also,
case,
the other side is not there.
my lord.
We'll hear it after due break. None
my lord, the
appears for
issue notice,
issue notice to the
My lord.
respondent.
My
All
lord.
right.
My lord.
Rule is made returnable in 6 weeks.
my lord,
Steps be taken in 3 days. Thus, the service is permitted.
my lord. Obliged.
Item number 4 for admission.
Third issue notice to the respondent. Yes.
My lord, please
Yes.
consider the method for the time being, my lord.
Who is for the appellant? No one. You there? Item number 4, yes.
Lordship, kindly pass over for time being. Lordship.
All right. Awesome.
Matter number 5,
For the respondent.
Okay.
My last observation was short time that there is some settlement. Already
Negotiation.
Settlement is arrived at, but notification not published. So I pray, my lord, some more time, so I will withdraw it.
Vigilant counsel, Mr. So-and-so appearing for the appellant submits that the negotiations which were going on between the parties have have culminated into an agreement, and thus, however, the notification has not been issued. He prays for and is granted 4 weeks time to place the notification on record. List up 4 weeks.
matter number 6,
Very please, your lord.
Yes, please.
My lord, this appeal, your lordship will find, my lord, is against the impugned order filed by the learned single judge, your lordship, at page 75, your lord.
Yes.
Now,
My
in
lord,
this case, my
if I
lord, the
may
learned
add-
single judge,
My lord, perhaps this matter has become infructuous, my lord,
Why?
because the impugned order which is under challenge here,
Yes.
my lord, the writ petition has been dismissed as being infructuous, my lord.
What do you say, sir?
I have a
my
copy of
lord,
the order.
Let us see.
My lord, we had the remedy under section 144, my lord, nothing, my lord. They, what, my lord, in this case, what
Sir,
happened?
you are
my lord?
against an interim order. The writ has been decided. What more is left, sir?
Now, learned single judge, while passing the, my lord, impugned order, interim order, your lordship has granted the final, my lord.
Whatever. The writ has been disposed of. You challenge that.
That too without hearing us.
That is another ground for challenge. Likhe, this intra-court writ appeal is directed against an interim order passed in writ petition number so and
Final
so.
relief has been given, your lordship, without hearing us, your lord.
Sir, that is a ground which you will have to take in the appeal. Why should we prejudge that issue? We don't know why you wouldn't appear. Your name must have been shown in the call list.
No,
Why
no,
didn't
the
you go?
first day, your lordship, the first day, my lord, we received the notice just, my lord, last month, your lordship.
So what of that?
After 1 year, your lordship, we received the notice of this particular writ petition, your lord.
Oh, so what? 1 year, how does that make a difference? How does that make a difference? Whenever you got the notice,
On the very motion day, your lord. On the very.
it's permissible. There is nothing wrong.
Notice was served upon us. Electricity was there, respondent number 2, we are not there, without hearing us, my lord.
All right. Against an interim order, it's so and so. Then counsel for the respondent has placed on record copy of the order dated 3/4/2023 passed in the very same writ petition which has been disposed of as having rendered infructuous. Since the writ petition itself has been disposed of, the instant writ appeal which is directed against an interim order passed in the very same writ petition has become infructuous and is disposed of as such. Needless to say that the appellant shall be at liberty to take recourse of the suitable legal remedy for ventilating his grievances. Okay.
I'm obliged, my lord.
The period of limitation, my lord, may be there, your lord.
For what? The disposal is on 3rd
Which is
April.
the appropriate court, your lord.
Which court? You have to go to Supreme Court.
My lord, my lord, they had civil court during the pendency of the civil court, they had passed an order, civil court has passed the similar order. High Court has passed the similar order, where we had to go, only we
That
had
is
to
what
go to
you,
the.
so limitation, if at all your remedy is time barred, file an application under section 5. Why should we condone the limitation in this appeal?
That is.
Thank you.
Liberty can be given, your lord.
We have already mentioned that you are liberty to take
Section 14.
take
of the
recourse of
Limitation Act.
all permissible legal
I
remedies.
am freeing, my lord, in view of section 14 of the limit.
In which court do you want to go, sir? Against which order do you want to go?
We'll have to examine, your lord.
So then, all right, even without knowing which order you want to challenge, we should extend limitation. It's not a COVID situation, sir. Thank you.
matter number 7,
Right, my
May please, your lord.
Yes.
This is with regard to, my lord, maintaining the basic amenities in the religious places, my lord. This is pursuant to the direction of the Honorable Apex Court.
basic facilities like toilet, water,
Where,
in the
Be
religious
precise.
places.
which religious place
My
are
lord,
we addressing?
Initially, it was originally one district, that is Dhuri district. Later on,
It has been expanded.
Honorable Court expanded this
Okay.
all district.
So do you have any reports?
I have received some of the report from the districts, but still some districts awaited.
So you all right, get the reports, then we'll pass a consolidated order.
that is.
Yes,
the-
that-
Right, all right, Mr. Comment Council, Mr. Soncho submits that the reports for few of the districts are, status reports for few of the districts are still awaited. He prays for and is granted 4 weeks time to file the same.
Yeah.
List
Deeply
of 4
awaited.
weeks.
Highly appreciated.
Item number 8,
May I please, your lordship. In
Yes.
terms of last order, my lord, we have filed our affidavit, but that is perhaps not on record, my lord. It was filed yesterday, my lord.
You are Mr. Datta.
My lord.
Mr. Datta submits that he has filed the requisite affidavit yesterday.
Yes, my lord, yesterday. it's filed.
All right. PIL in anticipation.
Not in, my lord, we have clarified, my lord, it's not in
All
anticipation.
right,
my lord.
the same be
Yes.
brought on record, list of 3 weeks.
Well, there is an order for payment of cost, my lord. We could not deposit because the authority is not specified. So lordship will specify the authority
The,
which.
the cost in terms of the order dated so and so be deposited with the Assam State Legal Service of
My lord. Deployed. Well, can I pray for a date, my lord? As senior counsel for outside this, my lord, sitting in this case.
May,
4th May, my lord.
yes.
Deployed, my lordship.
item number 10,
Upam,
Yes, Lordship. Lordship, I'm for,
the title has disappeared from the cover. Yes.
I'm for the private respondent of 5 to 20, Lordship.
Mhm. What is the matter about?
The Lordship, this PIL regarding one particular plot of land where these petitioners are doing Durga Puja. They
Mhm.
said that this list which is given by the respondent number 3, the Shilcha Municipal Board,
Mhm.
it should not be granted. And this is their case.
Lease.
Yes,
They have tried to challenge a lease by PIL.
yes, I'm
Lease.
the petitioners. I'm for the private respondent.
I understand.
Yes,
We are asking the petitioners are trying to challenge a
That
lease
Yes,
by way of the petition,
yes,
PIL.
Lordship.
Lease has been given to,
To the private respondent, Lordship. Yes,
for
from-
what purpose?
From pre-independence period, Lordship, this lease is from pre-independence period, Lordship, this lease is with us. And the lease is still 2024.
For what purpose do you give the lease?
Lordship, for doing the business over that plot of land. The petition, the respondent number 5 to 20 belongs to the Manipuri section, the Manipuri community belongs to
Yes,
us, and
yes.
they are doing some, they have traditional businesses out there.
Okay, so you have lent out that plot of land to them for doing their business.
Yes, Lordship. And on each and every year, this Kali Mohan Puja committee, they do their Durga Puja. We have no objection regarding that.
Okay,
But now they said that the lease cannot be granted to us.
so lease was existing since when?
1930, Lordship.
1930? Yes,
I'm
what
sorry,
do you
Lordship.
say?
Lordship, in this matter, also the engaged council is having some difficulty. I'm praying for an adjournment, your Lordship.
It is submitted that the engaged counsel, Mr.
Yes, Biswas. yes.
Biswas is not available today because of personal difficulty. List after 6 weeks. There's nothing otherwise also. They have to go to the civil court if they want. Yes,
item number 13,
counsel engaged to represent the petitioners in this PIL. Yes.
I'm
13.
for private restaurant, Lordship. In
Yes.
this PL, they have alleged that I have illegally occupied a 6 bigha of land, Lordship, of Jorhat Municipal Board.
Zorat Municipal Board. What is the board's stand?
Lordship, they only lease out for 14 lessons of land. From 2002, being a landless person, Lordship, I applied for for that land, and accordingly, they have allotted only 14 less of land. 14 lessons means 609 square feet, Lordship.
Hmm.
They have leased out, and accordingly, they have also Jorhat Municipal Board also filed affidavit, Lordship. They took several time for filing their rejoinder, and Lordship, this honorable court had ordered it 20 of January, Lordship, prima facie observed that there is no public interest is involved. Lord.
All right, none present for the petitioner. In view of the observations made in the order dated 20th January 2023, and after going through the material available on record, we find that no issue of public interest is involved in this petition, which is granted as a PIL. Hence, the same is dismissed as being devoid of merit and so also for non-prosecution.
Item number 14.
Lordship. Lordship, last order, your lordship, in this PIL, your
Pending application, if any, is also disposed of.
lordship had granted time to central government and the state government to file their affidavit in this PIL, your lordship.
Have they filed?
Not yet, your lordship. I have not received.
Yes. Central government,
So far as the PIL main player is concerned, Lordship, they are seeking a reservation in the vacancies of the state of Assam. Lordship, that is primarily to be looked after by the state, Lordship. Therefore, I may not be having too much of a say in this matter.
okay.
That is not the case, your lordship, because what has happened.
Lordship will see the.
So will we record your, maybe record your statement that you don't want to file?
Lordship, it may be kept open because at this stage, Lordship, if your Lordship will look at the prayer, Lordship.
Let's see.
Kindly
let's see.
see it, page 22, Lordship.
Hmm.
Of course, the committee was set up by the central government in terms of clause 6,
Right.
and it had made some recommendations. And those
Local
recommendations.
reservation, they want reservation for us.
That is what, Lordship.
People domicile in the state of Assam.
Yeah, domicile people, yes, we understand.
Similar laws have been passed in other states also, your lordship.
That I understand, but then primarily that is for the state to answer.
Lordship, there is a background, your lordship, because what has happened, this clause 6, the genesis of clause 6 is the Assam Accord, your lordship, wherein the central government and the ASU, All Assam Ganasangam Parishad, they had signed this accord, your lordship. And because there was a long drawn agitation which had taken place, around 860 people were martyred at that time, your lordship. And thereafter that accord was signed. So in that accord, your lordship, there are certain
All
safeguards.
right, what state has not filed its affidavit?
Lordship, initially, Lordship, before the implement petition, Lordship, we already filed one affidavit.
Okay,
And there, Lordship, in page 198, running page, Lordship, there in paragraph 5, we have stated that the last meeting of the subcommittee held on so and so, All Assam Students Union, the only existing signatory organization. So this one we are stating, though we have not filed any objection to that implement, Lordship. Lordship, I may be given some time, Lordship. I
so maybe
obtain
once
instruction.
the government files the fresh affidavit,
Lordship.
we can call upon the central government to respond.
Yes, Lordship.
All right.
Lordship.
First, Lordship, so far as this issue is concerned, Lordship, if Lordship will give me 1 minute's time.
Yes, yes, sure.
Lordship, if your Lordship look at the historical background, Lordship, it starts from 1937. That time, Lordship, the Jinnah had lost UP, then there were 5 provinces to be created. And Assam was tagged with Bengal.
Right.
And thereafter, Lordship, the influx came. And right now, Lordship, it is so much that Lordship, the local population has become minimized. The reliefs are
Cause is justified as per you.
that, Lordship.
Lordship,
But the government has to take a call.
Yes. Lordship.
Basically, you are asking us to direct the government to take a policy decision. That's what the PIL is about.
Lordship, there is a background which is there
We
because.
understand, we
Lordship,
understand,
because
but
what has happened?
whether such writ can be shown, tell us.
Lordship, because the
It's
stand-
nothing else but exerting pressure through the court. That's all.
Lordship will kindly see one aspect, which was your highlighted by the committee, your clause 6 committee.
Sir, we are asking you,
Yes.
tell us on principles,
Yes,
whether a writ court can direct the government to take a policy decision.
Lordship, we have stated that, your, I admit, your lordship, to that extent.
So
Lordship,
nothing
yes.
other than exerting pressure. You keep the PIL alive, maybe under this pressure, they'll do the things which otherwise, as per Ms. Chaudhary, may be justified. We understand,
Yes, sir.
but a writ can't be issued for this purpose.
37 years is over, your lordship.
So
Some-
we can at best say that we may request the government to take a decision expeditiously. Nothing beyond that. A positive direction can't be given.
The state is,
That will be encroaching on their dominion,
Lordship,
purely and simply.
Lordship. But
We may strike down a reservation. We can't direct the government to create a reservation.
But the issue of domicile, that has been decided by the apex court, your lordship, that there is a provision to give reservation.
There is
based
a
on
provision, but
domicile,
whether the state wants to give it or not,
lordship.
it's a different thing.
Let them
We'll tell you about,
let
we'll
them
tell you about
stand here,
the
your
National Law University. Most of the National Law University have given domicile reservation.
Yeah.
Rajasthan has still not done it.
Right.
So whether the court can't go on issuing writs for creating a reservation.
Right.
That is against the very spirit of Article 14.
Lordship, there is a background here, because unlike other states in India, your lordship, here the citizens.
We understand, sir, we understand.
Yeah.
We are asking you, what is our jurisdiction to issue such an
That I
action?
understand, your lordship. Only I'm highlighting to your lordship the background and the genesis. because of which
Maybe on a
there is
public platform, if we discuss, yes,
genuine
your issues are quite genuine. But whether a writ can be issued for this purpose.
State government.
all
may
right, let
submit
the
their
affidavits
affidavit.
come,
Let them
but
clear their
We,
stand,
we,
your lordship.
we make it very clear. A writ can't be issued in this matter. Well, the learned DSG, Ms. Chaudhary submits that primarily the prayer which is made in the petition, the PIL petition, is to seek a direction upon the state government to introduce domicile reservation and thus in the government undertakings as well as in the private undertakings. Thus, as per Ms. Chaudhary, the central government is not having any significant say in this controversy. Nonetheless, reserving his right to file affidavit pursuant to the submission of the additional affidavit by the state of Assam, Ms. Chaudhary. Ms. Chaudhary submit that his right to file an affidavit may be kept open, and he would consider the same after the state of Assam files an additional affidavit pursuant to implement of who has been implemented.
Lordship, that who.
Pursuant to
parties have
the
come,
implements made wide,
Lordship, I have some reservation in this regard because two implement petitions have been filed.
additional affidavit
Lordship will
to be
consider.
filed by the state of Assam.
Lordship.
List after 4 weeks. For implement, we'll consider after they file, the state of Assam to file, government council to file additional affidavit in response to the IA number so and so, IA number so and so, both. List after 6 weeks.
Obliged.
Deeply obliged.
Item number 15.
Yes. Yes.
Lordship, in this case, Lordship, only issue is whether the hard copy of the technical bill is required to be submitted or not.
Technical bid.
Yes, Lordship.
Okay.
It was an online tender process, Lordship, and petitioner's tender was rejected for the reason that it did not submit the hard copy of the technical.
Is there a requirement in the
Yes, Lordship. Lordship, may kindly see paragraph. page,
invitation, bid
61.
invitation document? There are
Page 61 of the bid, Lordship.
bid, let's see.
Yes, format of signing of the bid. 17, Lordship.
61 page,
Page 61, Lordship.
format and signing.
Yes, Lordship. Lordship,
Yes.
kindly read, the bidders shall submit both technical and financial bid through online. One hard copy of the technical bid along with supporting documents as per ITB and clearly mark hard copy of technical bid. In the event discrepancy between online and manual technical bid, the bid will be created. Lordship, this hard copy was not submitted.
So
Actually,
there is a exercise of comparison. Once the hard copy comes in, there is a comparison,
yes,
and if there is any discrepancy, the bid is
we can say. So
failed.
that is why for submission of hard copy is necessary.
These conditions are not negotiable actually.
Yes.
The conditions of the bid,
That is why-
NIT,
Secondly, Lordship, in the meantime, bid was allotted to some other contractor, Lordship.
work order
He has completed the work in. the bid.
completed.
Yes.
On second part, my lord, just my lord, page 63 for a moment, my lord.
Yes.
Kindly see, my lord, under clause 19 and B,
Yes.
it is they who are saying
hard copy of bid document need not be submitted along with supporting document.
Yes, that is at the particular stage. These are, this 17 tells about signing of documents. So when the signatures, bid is to be signed, the hard copy has to be there. This is at the earlier stage.
No, that is, my lord, clause D, my lord, page 62, submission of bids, how bids has to be submitted. Page
Understood,
62.
sir. But once the bids are received online and the documents are to be finalized, at that time the hard copy has to be given.
Documents were filed, my lord. Only that bid document, bid was not, my lord, that form was not submitted.
That is a mandatory condition, sir. Yes.
Since they have completed, my lord, it has become instructions of my lord. I may be at liberty, my lord, to approach appropriate forum, my lord, for any other relief, my lord.
All
available
right,
as
all
per law,
right.
my lord.
This intercourt writ appeal is directed against the order dated so and so passed by Leonard Single Judge in WPC so and so, whereby, comma, the writ petition preferred by the petitioner seeking to challenge the cancellation of our bid for such and such work pursuant to NIT dated so and so was dismissed. The Government Counsel, Ms. Nayak, states that during the intervening period, comma, the bid of the private respondent number so and so was not during the intervening, the bid of the pursuant to rejection of the bid of the appellant, comma, bid of the private respondent number 9 was accepted, and the work under the NIT in question has already been completed. In view of this development, comma, manifestly, nothing survives for consideration of this court in this writ appeal, leaving the writ appellant at liberty to take recourse of the suitable legal remedy for ventilating his remaining grievances, if any, comma, the instant writ appeal is disposed of
My lord. Obliged.
as infructuous.
Obliged, my lord.
Yes.
Sorry
Item
for
number-
the inconvenience. In item number 13,
Yes.
I'm appearing for the petitioner.
Yes.
Yeah, I was in legs in court number 6.
Yes. All right.
That's
What do you want to say on merits? Argue.
Lordship, I want to withdraw this petition.
All right.
with
Counsel,
liberty.
Ms. MS so and so, craves liberty to withdraw the PIL petition, hence the same is disposed of as withdrawn.
May I please, your lordship? Lordship, I'm appearing for respondent 3 JMB.
Mark attendance, whosoever is appearing.
Data leak.
Attendance will be marked. Yes.
Item number 4, passed over matter.
May I please? So, Lordship, this matter is regarding promotion, my lord.
Yes.
This honorable court, my lord, on 19/12/2022, my lord, directed the respondent to file their affidavit, my lord. Till date, no affidavit has been filed, my lord.
Affidavit has not been filed.
If it was prepared, there was some development in the matter, my lord. I had to send it back day before yesterday.
All right.
I'll file it within
Mr.
1
Mazumdar submits that he needs some more time to file the affidavit when we want.
My lord, immediately after the vacations. my lord,
He needs 2 weeks time, further time to file the affidavit in a position list the affidavit be filed on or before 25th April. Rejoinder affidavit, if so required, on behalf of the appellant may be filed by the next date of listing. Denotify on 15th May.
Yes.
15th May.
Obliged.
One stage can be curtailed.